pretty good picture. So those of you from UTech in particular who may be going to law, you can look at some of the areas, not only of work, but some distinguished individuals you can acquire some knowledge from. All right, thank you. Good. Okay. We have apologies from Mr. Mark Golding, and I have apologies from Ms. Kerencia Morris, who is not well, Mr. Terlong, and Mr. Fitzjackson said he'll be very late.
Senator Scott Motley has also sent her apologies. She is ill.
All right, we had gotten to, I think, page 27 of our chart, looking at declaration of criminal organizations. The Ministry of National Security made some recommendations, as well as the JCF. Page 27, remember that. And this is actually a new provision as part of the declaration. AG, any question on this? It's a definition of, well, it's the declaration of the grouping by the Commissioner of Police applying to the court. Okay, number 9. We're on page 27, looking at the criminal declaration of a criminal organization. And the police said that we asked for such.
Chairman, the question that arises, if any application to the court would have to have some basis which would satisfy the court. And if you are able to make that declaration, the question that will arise is, why are you not able to charge, since the structure of the act makes it illegal to be part of a criminal organization? So at the very least, you would have to know who the minimum members are, and that they are operating together for illicit activities. And if you have that, the question may arise as to why not proceed with a charge instead of a mere declaration. And what is the effect of a declaration? Again, given that I sense the intention is for monitoring purposes, but if you have a law which criminalizes an activity, and you're indicating to the court that you know of persons who are engaged in that activity, and persons would be presumed innocent until they are proven guilty,
you ought to charge them.
Then why not charge them? Now, I can understand if, having charged them, you would want to, in addition to the sentence imposed on them, monitor them for other activities if they are not confined. But then the penalty under the law is also one of imprisonment. So we have to think through.
I can see the reason for asking it, but I need, as I say, I can see the problem with putting it in, declaring it, because I suspect the reason is for monitoring, and if you're monitoring a criminal organization, you may know towards three or four enough to justify declaring it an organized criminal organization. But then you should arrest those three, because the idea is really to monitor the entire gang and to see if you can pick up all of them, whether it is 20, 30, or 40. Now,
I just like to ask, without the declaration, what is it that would prevent the monitoring?
Sorry, Chairman, if I may, from the JCF side, the purpose of the declaration was for the purpose of mandating financial institutions, once the organization is declared to be such, mandating financial institutions to make certain types of reports, which is similar to the reporting regime under the Proceeds of Crime Act. And why not use POCA? Because it's different circumstances. Because we took this from the Terrorism Prevention Act, right? So a similar regime exists under that act where the DPP can apply if there are reasonable grounds to believe that an entity is a terrorist entity. So it's a different standard from the criminal court where you're going to have to prove beyond a reasonable doubt. So this is a tool that can be used before someone is charged, where you have reasonable grounds to believe and the court is satisfied that a person is a member of a criminal organization. And once that declaration is made, financial institutions that have any property for that person would be mandated to make reports on the property and make reports on any transactions that they think are related to the property.
So could you allow Mr. Bailey to, since he was coming in from the...
Yeah, no.
Question before Mr. Bailey comes in. Chairman, from your understanding, what would prevent the police, if they have reasonable cause to suspect that someone has engaged in criminal activity and as part of the investigation they would want to look at their financial history, whether for illicit gain or not, to make an appropriate application? What in law prevents that from all the many pieces of legislation we have and, I mean, even the common law?
Well, there is a regime under the Proceeds of Crime Act to apply for disclosure orders. And that is something where we're asking the bank to provide us with documents, for example, on a bank account of somebody. But it is a different standard that you would have to meet rather than saying that a person is a part of a criminal organization. And that order would not require the bank to continuously report as to whether they have any property for the organization. It's something that says, all right, this person has a bank account, I want a transaction history for the bank account that already exists, so you give them the past history.
Chair, if I may, yeah, my colleague averted to the fact that this was taken, at least the concept is taken from the Terrorism Prevention Act. And I think therein lies the problem. The power of the DPP to declare an entity to be a terrorist entity, like in many other jurisdictions, comes about because of the very nature of terrorism. You may have an entity, an organization, calling itself, for example, a charity, but that charity is being used to funnel money to terrorists, either locally or internationally. So it might be, on the face of it, a legitimate entity, but it is discovered or suspected that it is not. That is where that power comes in, because that organization is operating ostensibly, legitimately. You may recall that several months ago when this came up, and they also have to be on the UN list. But there are other examples of this. In Australia, for example, I think I use this example, where they had problems with biker gangs. These are biker gangs that they're signed, there's an address, a sign, a website, they're operating very visibly and publicly. But it was discovered that they were also a front for drug smuggling, for people trafficking, for lots of other things. And so they put in a similar kind of regime, because these are organizations that were pretending to be clubs, that they're operating legitimately, and one could not say that everybody in that club was a criminal. And so a similar kind of regime was put in place for that. But what we have in Jamaica, what we're looking at now, is activities, as the Attorney General has pointed to, that are criminal from the very get-go. These are not entities that have a sign somewhere advertising their presence and inviting members, for example, or claiming to be something legitimate. These are gangs of men, predominantly, who are engaged in illegal and criminal activities. So it seems to us, to try and use this kind of a regime to impose this regime onto that would not really solve any problem at all. And as been pointed out, POCA already exists for doing exactly what it is that the police is seeking to do.
And that's you, AG.
Chairman, when you look at the law that we're reviewing, every single offense that has been created under the statute requires proof of the existence of a criminal organization, every single one. And like I say, if it is that you have the information, why not prove? Why not move to charge? We're getting a clearer sense of the approach to be taken by our public officials and the agents of the state in the post-charter era. And there are specific dicta which indicate the kind of treatment and the approach that is to be taken. So while it is understandable that you want tools to monitor a person, no one can act arbitrarily. And that is why fundamentally at the foundation level there must be reasonable cause for suspicion. And it is on that basis you proceed to do any of many things. That is why arbitrary stop and arrest, arbitrary search is not permitted. So when recommendations are made, there is a requirement to interrogate before they're put forward.
I'm getting the sense that from that the other legislation can cover this effectively. Is that the view? In terms, because what they're seeking here is the increased capacity to monitor the gang, technically, because that's all they could be doing. Because if you have evidence, then you charge them. Now, I'm getting a sense. Am I right that with what we already have in other areas, proceeds of crime, if we can in fact ask for a declaration from the.
If I may, Chair.
What I don't, sorry, go ahead, Maurice. What I quite frankly don't understand, and I need some help on it, because I don't understand. If you look on what the JSC say, there should be a provision for the court to declare an entity to be a criminal organization, and then you monitor that organization. And for example, you go to the bank and you say you want to monitor that organization. But do these groupings operate as an organization and would have, for example, an account at a bank in the name of this organization? If it doesn't, if they don't, and I don't think they do, what organization would you be monitoring?
So I think it was recognized and appreciated prior that it would have to be particular persons that we're saying is a member of the organization. And the order would recognize those particular persons. And as a result of the order, financial institutions would have obligations to report whether they hold any property for those particular persons. Under the Proceeds of Crime Act, there is no similar order that you can obtain for a financial institution to report whether they hold property on a quarterly basis for a particular person.
Whether what holds property for a person? The organization?
Financial institution.
Oh, yes. But they are monitoring individuals. So what is this declaration about the organization? And describe the nature of the organization and of its distinguishing characteristics under the Ministry of National Security's input. The Commissioner of Police may apply to the court for a declaration that a particular organization is a criminal organization. I really don't understand it, I tell you the truth, because it's unlike in the Terrorism Act, you know, as Dr. Bailey had explained. And you have these...
Stay a little bit close to the mic, man. Speak a little closer to the mic. So
they complain every time. You have these these terrorist organizations, well identified, well known, carry out terrorist actions in the name of the organization, etc., etc. So it's a totally different platform from what we have with these gangs. A totally different platform. So, Chairman, my considered view is that we should not consider this any further, and that we move on to a new area. No disrespect meant, of course.
None taken.
Chairman, I think at the heart of the matter is a difficulty faced by the police in investigating persons suspected of having committed crimes or are committing crimes, and particularly when they are in a group. I think that is at the heart of the matter, because if and what tools are available to enable them to monitor during the investigative stage with a view to gathering evidence for a charge. I think that is what the recommendation is seeking to achieve. So earlier in the committee's deliberations, a recommendation was made for us to look at an entire suite of investigative tools, including surveillance tools, examine what currently exists, where they're deficient, and to revise and to bring that together. But
to bring this on the Intercept Act as well, which is coming.
But I share the view of Member Knight that the recommendation as is could not be accepted.
So Bailey, you were saying anything more? I know you were. Non-legal man, but they seem to be irrational. I think I'll have to pull this one out of it. The question of tools will, of course, arise in a different forum, and I think it's really the capacity. I don't even think it's so much tools, members. I think it's really the capacity of the investigating officers to convert information that they are allowed together into evidence, and how to use the existing legislation. You'll have to look at it again, Ms. Ward. We'll discuss it outside of this, because it is our biggest problem is essentially the criminal organization and gangs that we need to monitor, but we have to do it right. Otherwise, when we get to court, we'll still lose out. Right? Dealing with Section 5 and 15 of the law. Essentially, it penalizes the owner, occupier, or person responsible for the management of a premises who knowingly cause the said premises to be used for commission of offenses. And Section 15 deals with the fact that an accused is unable to properly account for property which is disproportionate to his known source of income. This would have to do, I'd expect, with the proceeds of crime and unexplained wealth. What are we incorporating here? Well, Section 15 and 5 is only a little bit trickier. That's the next page, 29. One is seeking to penalize anybody who allows their premises to be used for the commission of the offense. And in the case of, say, a gang who rents a property to put on a show, we'll have to prove that the person is aware that the person is rinsing money, which could be challenging. The second part of Section 15 is a question of unexplained wealth. It would appear to me from a lay, the court to have considered allow the court to have consideration of the fact that an accused is unable to properly account for property. And we're having a challenge with that now. And we, Miss from CPC, who is it? Miss Sherlock. Yeah. That's one of the challenges. We have a bit of a challenge with the unexplained wealth clause in the process of crime, right? I'm saying the Section 15 seems to be alluding to unexplained wealth. Is that one we're having a challenge now? On page 29, the recommendation from MOCA to allow court to have consideration of the fact that an accused is unable to properly account for property which is disproportionate to his known sources of income.
The immediate question that arises is whether that provision exists elsewhere and what prevents it from being used under these circumstances. If it is that in the Proceeds of Crime Act, it is not crafted in the way that would allow for it to apply, because I sensed from the JCF a sense of difficulty that they think even if a provision exists elsewhere, the view is that it applies in a particular context but not in another context. But within the jurisdiction, and not just here in Jamaica, regionally under the anti-money laundering regime, the idea of unexplained wealth is something that has been targeted, and it makes good sense.
Being looked at on the amendment to the Proceeds of Crime Act, and it is posing a challenge right now. So I suspect this clause will be covered in that ways being, but I know it hasn't gotten to you quite yet, but I know there have been some challenges. Any of you speak on it, but I know it has been brought to my attention. There's in fact, they have a request to even delay that section of the legislation to get it right. I'm not sure exactly what it was. Mr. Richards?
That's correct, Minister. So we have had some preliminary discussions with the help of SG and the CPC as well, with respect to some proposals that we have for unexplained wealth. As it is, we're going to be going through some further consultation with stakeholders to try to flesh out how it is that we will work out such a regime to ensure that the issue of constitutionality, which has been raised by the AG's chambers, are fully ventilated. But it is something which, as you know, Minister, we're putting priority on.
If once we get on the process of crime, would we need it here? I think that's the other question as well. If you have it in one...
No, we don't think so.
You would need it here, but we need to get it sorted out. But under that amendment, the AG said we're going to come back. So the suggestion would be to leave it out of here, leave it out of this now, with knowledge that it should come under the other legislation.
No, Chairman, the issue of accounting for wealth and examining wealth against legitimate sources of income is not something that can be looked at in isolation. There's an entire legislative scheme that deals with it and how you progress from one stage to the next. And it is also looked at in conjunction with the tax laws.
The staff members of the SG department to take a second look, and in fact, it has been posing challenge to get the whole suite correct. I think that's what's happening right now. Yeah. So the better view is to leave it out of this and get it right, wherever it is going.
I believe the first part of the recommendation, Chairman, can be considered. Mm-hmm. You don't penalize until you've found someone guilty, so it comes out of sequence. But the use of premises for the commission of an offense under the Act. But again, it goes back to a core finding that would have to be made, the existence of a criminal organization.
Come on the evidence to prosecute the gang members and then you'd have to go back for the individual who allowed them to use the premises, I suspect. And have them.
Quite frankly, Section 5, I understand the need to penalize owners, occupiers, etc. But there's a difficulty with the mens rea, just knowingly. To me, it has to be knowingly and or recklessly. Let me tell you where I'm going. Something like, not even so much so, because, you know, we have to look at some protection for these owners.
That's a matter I need to clarify, because if someone comes to me, rent a venue to put on a function, I may not be, you know, the person is essentially to put on a function that will earn them, you know, help them to earn some money, literally. How do I?
Well, they say knowingly, but I am going a step further. That you can know that this is a criminal gang. But as you said, they've come to put on a function. Let me tell you something. You could be a dead owner. You could very well be the occupier today, and the same night you become the testator.
I hear you, Senator. And for those who are listening, you remember that the Senate is the upper house, tasked with guiding and looking in more detail at what we're doing. But what's your suggestion here, Senator? That how do we protect the owner?
Yes, you see, what you want is an owner who is a part, or an occupier who is a part of this kind of criminal activity. That's a person you want.
If you go that route, you don't need the legislation, except because once it's a part of the gang.
No, I don't mean a part of the gang, but a part of criminal activity. And so that owner finds no difficulty in allowing a gang to use the premises. No difficulty at all. But there are circumstances where the owner may know that the persons who want to use the premises are gang members, but can't say no. So it must be, it has, sometimes what we put in legislation is a defense. And maybe we have to consider here now whether this piece of legislation ought to have a defense. It is a defense if, and we state what the defense is. So, are you following me, legal? Yeah. Because if you leave it just like that, my fear is that innocent persons could be charged, and they are innocent even if they knew. But the circumstances are such that they would be so endangered if they said no, that they have to acquiesce.
Well, I see where you're going, Senator, and I appreciate it, because what you're saying here, the language has to be changed. Because if you say knowingly, although he knows, he cannot say no. And the circumstance, there has to be something to implicate that he is willingly participating in this activity. And I don't know if that is a useful sector. But
Chairman, I think we can leave the specific drafting to the drafters, but we have to be clear what it is that we're getting at. What it is that we're getting at. My understanding is that in order for gangs to successfully operate, they need resources. They need bases, a base, physical base, with a home where they plot, carry out, right? And you have persons who either knowingly make premises available to them or fail to monitor through whatever relationship there may exist between owner and occupier what the premises are being used for. And it appears that the recommendation is placing a duty on the owner or occupier of premises to ensure that whomever occupies that premises, whomever is in possession of it, is not using the premises for illegal activities, and in this particular case, in relation to gang activities. And I think we have to be clear what we are targeting. Because we do have provisions in other laws where premises are used for certain activities. Ultimately, it's not just that the person who permits it facilitates the use of it, but the premises itself become liable to being forfeited to the Crown. So we need to be clear what we're seeking to achieve.
Yeah, both is what the draft would have looked at, because I can see what mischief there, but I can see the ease with which the innocent can be involved. I mean, yeah, the premises to be used as activity. As simpler one is very simple. I mean, it is entertainment, a big part of Jamaica's scene. If a gang is involved in entertainment, it's a simple round robin. So the gangster own one bar, and when he's to go to the next bar, and he uses the bar as a means of getting his money legitimate. He's going to the next session is with an innocent bar owner to have the next round robin. How does that innocent bartender? He cannot say no in the context he's in, and how do you prove in a sense?
There's an added issue, Chairman, and we do not have the luxury of passing laws on the basis of anecdotal evidence, nor do we have the luxury of not taking into account the reality of our society. And we know that there are various communities where owners of the premises have fled because of the level of crime and violence, and others have occupied. And we need to clarify who exactly is being targeted. That's why the work has to be done, the analysis has to be done, the data has to be gathered to enable us to make the kind of decisions that will effectively achieve the outcomes that we're seeking to achieve.
Okay, so we keep it, I think, in the discussion. Those who are guiding will have to look carefully at it. Question, Miss? No? You're asking a question? No? All right, thank you. So we'll keep section 5 and look carefully at what emerges in terms of that, and we'll leave section 15 out for further review elsewhere. Another tricky one. We need all the yes. The use of control orders on suspected persons similar to those present within the Serious and Organized Crime Control Act of South Australia. Well, that's the thing we're looking at. How does this fit into our constitutional construct? And how do we get to the point of this control order? Because this comes back to the watch list and all that kind of activity, am I right, AG?
Again, Chairman, some of my earlier comments in respect of the proposal for the earlier order would lie. So we always have to start with the fundamental. constitutionally, a person is presumed to be innocent until found guilty. We laugh at it and we laugh at it, but it is a fundamentally guaranteed right that we really can't skip around.
I agree with you have the police officer,
Right.
the
And the state has to reacculturize its mind to the context in which it pursues investigation of persons, however challenged we are. And we are challenged to the hilt, Chairman. And you know that in your capacity, in your ministerial capacity. But we have to make the shift, and the state will have to lead by example in respect of the approach taken. Gone are the days when you disregard the law. Gone are the days when you think a man is guilty. What that culture of investigation and law enforcement in bracket has done is to delegitimize the state and the administration of justice. And make no mistake, Chairman, I am extremely aware of the challenges. But we have to bring critical thinking to bear on the issues facing us so that proposed solutions will be effective. You can't be at large to monitor someone. You have reason to suspect that they have committed an offense. I understand it may take time because the context of criminality very often points to victims themselves being part of the culture, witnesses being part of the culture. It is a reality in certain communities. And what we're seeking to achieve, having regard to those realities, how can we design rules that will be fair, but will allow us to effectively investigate so that we can gather evidence, and at the same time to ensure that persons suspected of criminal activities do not flee and escape while important investigation is taking place. So there is a place to monitor, control the movements if need be, but it can't be open-ended. It has to be properly thought out. And what is proposed here doesn't give any indication of that thinking out, but perhaps the ministry can say more and clarify for us.
I too would like some clarification because I have no idea what this means. None whatever. So if I could be told, maybe I'd support it, I don't know. But I can't support the unknown.
Mr. Chairman, these recommendations are actually coming from ZOSO. Recall at a former sitting that we were instructed that they should be discussed here and decisions taken as to what will be done in relation to
they're
the
part of the
proposals.
original zones of special operation. Are they part of it now?
No, they are not. They are not. They were removed. No, they are not. They were in
Can I just clarify?
Okay.
They were in a schedule to the bill. When the bill was tabled, we had, so you know that the act that has passed has schedules in there, and there's a schedule that actually has amendments to the Constabulary Force and the Firearms Act, which were approved. There were also proposed amendments in the bill, in the schedule, but they were withdrawn. They were withdrawn because there were some concerns about that for further consideration. But then it was agreed that it would be brought to this committee. The ministry would have taken it to this committee to discuss. We have done a little research on control orders and their use in England, and the use in England is not been. You want to speak? It's been a little controversial, so it's not.
Can you give me that in practical? What does that? What do you said? What do you mean by control orders now?
Please state your name for the record.
Sorry, well, it's on that. It's Jeffrey Foreman, right?
Foreman from AG's office.
Attorney General's Chamber, that's right. Yeah, the United Kingdom has had a history in using control orders as part of their response to the threat of terrorism and so on. That experience has been fairly controversial. There have been a number of cases that have gone all the way up to the House of Lords, as it then was, and now the UK Supreme Court. In most instances, in these cases, legislation itself was not challenged for its compatibility with their human rights regime, but specific instances of application of the orders were challenged.
Legislation wasn't challenged, but specific use of it was being challenged.
Right.
Well, say what the control. I mean, what the individual now becomes subject to.
Right, the individual. Right. Okay. Yes, sorry.
So
what happens in their in the systems that they had was that a particular individual who becomes subject to a control order, certain limitations on their ability to move about freely, to communicate freely, to travel and so on would be circumscribed. And the cases invariably challenge the tailoring of each of those particular provisions. So, for example, an individual may have been limited to staying in a particular geographical area, limited in their access to communicate to family members and other persons. And the usual arguments were that these initiatives improperly infringe their rights under the Human Rights Act of the UK. Now, at some point, the UK repealed, in large part, the provisions of the original legislation that they did and replaced it with another regime, which my research showed has not been challenged as much, but I also think it hasn't been used as much either. So that might be a reason. So it's an area that has its difficulties.
And then with our Charter of Rights.
And we have the complication of our charter and the need for, as the court has said, evidence-based policy crafting.
Chairman, just to say, or to clarify, that I am acutely aware of the need for stringent measures where appropriate. But I think fundamentally, we understand that we can't license the police to act arbitrarily. So where the reasonable ground exists to suspect that the person has committed an offense, and for example, that before you're able to charge the person, their free movement or enjoyment of the full suite of freedoms may imperil the investigation, a proper case may be made for curtailment. But there is a standard that also has to be met. When the proposals were lifted from the ZOSO law, the idea was for further work to be done, not merely for them to be relifted and put back here without the further analysis, because at the time, the full analysis had not been done.
Ask the question I did in this. Currently, I know courts can give orders to say to David, you should not go to this community. After bail.
You are charged. So this speaks to those suspected. So you begin with the suspicion. You move from suspicion to charge if you have sufficient evidence. And then you can move either from charge to conviction or acquittal. And if you're convicted, different consequences flow than if you are acquitted. So we have to think through the entire spectrum. What can be done in the realm of suspicion when the person is categorized as a suspect is very different than what you can do after the person has been charged. And also, if they've been charged and not convicted, or if they've been charged and convicted.
Alluding to pre-charge and suspicion. That's a pretty tricky area to deal with.
So we have been looking at at what can be developed at the pre-charge stage, where the person is a mere suspect and you're about to build a case. Chairman, the jurisdiction is replete with examples of persons being scraped up, put in the court, or charges being preferred without any evidence. People languish in court. So we have good examples and a fair bit of data that needs to be collated, disaggregated, and analyzed to enable us to further that work. It can be done within the constitutional framework, but the work has to be done.
Essentially, this is not yet ready for legislation. So what
saying it should necessarily be excluded, you know, yeah. Chairman, but further work and analysis needs to be done.
All right. Because what you're saying to me, this involves impairing fundamental rights, which can be justified under certain circumstances. So there has to be a clear bar established that prevents arbitrary use. Am I name interpreting? All right. I think I can. Well, let's just finish this page and we look at what you go. Use of unexplained wealth order. We just discussed that on the other side. Are we sticking with it in this bill? And there was supposed to be more work done as well. Any comments from policy, Mr. Richards? Any unexplained wealth? We just looked at it on the previous page, and again here now. And my understanding is being discussed under the process of crime. Do we need to continue this discussion here? Okay. Organized criminal registry watch lists. Yeah. One of them discussed extensively, and I'm told any legitimate way of establishing a watch list of gangs is there.
The issue of the watch list has been discussed in different fora, as you are aware. It may be useful for us to get some understanding of how, for example, this jurisdiction knows a wanted man's list, and the use of many lists by the police, and sometimes used quite effectively. Now, you persons are published, their names and persons of interest. Can we get some real data from the JCF through your ministry as to how it has worked? What are the deficiencies? Whether it needs to move from an administrative tool to become a legislative tool. Because I understand and appreciate the value, but again, context matters. And we still have to design our tools within the constitutional framework. So my frustrated plea is just for some analysis and some work and some data to come before the committee. Chairman, we can't use this review process and come back with a law that is going to be ineffective or does not reflect the reality. I remember legislation continue to speak, and it is our hope that we are not going to be at this reality ad infinitum. But there's a level of thinness in what is presented that concerns me greatly. Mr. Chairman, I'm looking forward to when the laws are really stringent and have teeth, and when used will yield a result and will cause the criminal to shake just to think before embarking on their criminal activity. But what we have is we pass the laws, we're not even implementing them, we're not effective. It's as if the agents of the state don't even know what tools are available, and it bothers me greatly.
Well, we have discussed about, sensitizing agents of the states once we pass the laws, and we also have to look at them. But in passing them, well, to have a watch list, you'd have to have a defined organization or a defined reason for them. If you're going to, and we are back to what was raised earlier in the session, if we have enough information, evidence to name the gang members or name the organization of gang, then we should charge the individuals. Now, so currently, the CIB can have a list of people they are monitoring for intelligence and evidence gathering, but put them on a formal public list seem to pose a challenge. Am I right?
Sorry, Chairman, if I may, if I recall the deliberations from the committee to some earlier meetings, there was an agreement that the JCF would have come back to the committee to state whether or not the watch list was required to be legislated. And I think they had written formally to say that they would want for it to remain a covert intel tool and not to be legislated. So this, to my understanding, is not supposed to be moving forward.
Okay, Mr. Richards, because you see at the end of it, there's a comment here that the first is in keeping with the problem that what this could be one of condition of the bail. I see here. I think that had really alluded to the AG actually asking for what bar would you use, similar to Section 14 of the Terrorism Prevention Act, which I am not aware of.
Again, there is a failure to appreciate the powers of the court and also the difference between being a suspect and already being charged. You don't get to the issue of bail unless a charge has been preferred. And upon an application for the grant of bail, the court has the power to stipulate conditions. The conditions are not plucked out of thin air. Each case is determined on its own merits. And you have to indicate to the court what may be appropriate, because at the end of the day, you have to ensure that the person charged will return to stand trial. If you have issues with the interference of witnesses, or if you have reason to believe that the person will flee and therefore not return to stand trial, or that your witnesses will be interfered with, or there may be any perversion in the course of justice. But you can't just allege without putting some material forward.
If what you're saying is, if there is a charge that has good evidence, they can make an application to the court to have that person monitored very carefully, if monitored at all, if giving bail at all. Am I right in? If charged. Can you have give me three decisions? Yeah. Suspect, charge, conviction. And the conditions, of course, of all three vary. A suspect, you're being monitored to get evidence. If you are charged and you go to court, and the court can evaluate the evidence before finality and take some decisions. Of course, if you are convicted, then that's a whole different scenario.
Somebody who is convicted. You see, I don't understand this watch list.
The watch list. I want your comment. So, indeed, if the person is convicted of being a member of a gang, once they leave, their name can be established as a gang member. Am I right? That's the one watch list. Is that?
Those persons are to be watched in prison. That's why they have correctional officers. Because I can't see someone being convicted for an offense.
What I'm getting at,
that would cause them to be fined or admonished and discharged. So
when the person leaves prison, like now, I get information on someone who is a serial sexual offender, which means they have been charged and committed.
You have a sexual offenders registry.
Right. Now, what I'm asking, given what I've been said here, if the person is unknown to be a member of an established gang, can I then establish a registry for those individuals who are convicted.
After this person spent 15 years.
Yes.
So you're going to put them on a watch list.
Yes.
I see. And do you at all believe in this whole concept of rehabilitation?
I'm with you, but that applies to the concept can apply to Rwanda. So there are a number of offenses in which individuals are placed on a watch list which have to deal with it. Serious sex offenses one.
I don't know if those.
If they are
I don't know if the legislation that provides for this watch list.
No, I'm just asking, but it provides for it in sexual offenses. It's a registry.
You know what we need to do? Catch the people. Convict the people. Those who to go to prison, go to prison. Rehabilitate the people.
No.
And thing.
What
we're doing is we're going all over the world. Pick out some little fancy provisions and put them in legislation. We don't know how these fancy provisions have worked, if they have worked, what have they achieved, but we're importing them into our legislation. Just like that. It don't make sense. And you know, you have to see the whole scheme to know how the parts fit together. You can't just go pick out something because it sounds good and put it within your legislation. And I notice, peculiarly enough, I don't see any comments from like Norman Manley Law School and the JCF and so on. So it looks to me, I wonder why they haven't commented.
I hear you loud and clear, member. I'm going to ask the SG want to make a comment because now what I'm trying to figure out is there value in having such lists for such some kind of scheme for gang members? I'm just asking, is there value? Because we have a challenge with the gangs, and they are the criminal organization, or they establish, and they have fair longevity in Jamaica. Even if they change their names, which is where they keeping track of the individuals could be of value. Can be done properly within our constitutional construct. And where would it come in? Whether it is suspect, charge, on for the period of charge, and trial, and post conviction. And I don't know if there such a. The SEO is going to make a comment.
Right now, from watch a suspect. What prevents them from watching a suspect? Of the JSC Act. So, you know, you don't just pluck something and put in legislation. There must be a purpose, a reason. You must have some
learned colleagues. And I'm being educated at the same time.
Interestingly.
Just 1 minute, AG. All right, let me tell you now. And of course, I'm with the Ministry of National Security. Well, all the departments here represented. But for example, was this something that the JCF and the ministry consulted on and came to a common position? So am I to take it, if that be so, am I to take it that the JCF, they support that which is recorded here? I just want to know.
The JCF was of the view that it was not necessary.
Member, what came out of the discussion, if you recall, is that rather than a watch list, a recommendation, it could be placed somewhere in it that PICA is allowed to notify the JCF where such a person is under surveillance. Passport immigration, yeah, that if the person is going to travel, then there would be a scheme could be established for them to notify the police in terms of
a person who has been convicted, serve sentence.
In the other activities, so what's the surveillance?
And if the person is going to leave the island, what? The state is saying that it reserves the right to put a stop order on the person.
I know it was saying it would wish to know his movements because the person is moving. If the person is a known gang member.
PICA issues the passport. Does PICA monitor the travel
when they travel.
records?
The PICA is aware when they travel. It would be whether or not it become a requirement that if a person who is identified as a convict, no released gang member, for a convicted member, that PICA would inform the police routinely rather than the police asking, or the police have the authority to ask for anybody.
So how would PICA know that the person is a convicted gang member? Because PICA's records. Don't ask me if one has any conviction. PICA's records must be
what is here?
PICA's records must be generated.
Yeah, what is here? What is it documented here, member?
Let me finish.
No, what is documented here? I don't think you're there.
PICA's records.
No, PICA. There's some arrangement.
No,
made.
Because PICA's records come from your immigration, your application form for your passport, and your immigration cards.
Saying, member, you'd have to establish by law an arrangement for the police to inform PICA prior, so that technically PICA would have a watch list.
And then when somebody gets to the airport to leave, somebody out there say, "Oh, you're on a watch list, you can't leave." Look here, let me tell you something.
No,
cut the nonsense.
No, there's no restriction on his movement. It is said that the police.
But you know there's going to be abuse. And what do you gain from it? Look here, let me tell you something. Don't get into this mood where you legislate everything and you begin now to whittle away at rights and you turn this country into a police state. Stop it. That I see that is where we're going. It is wrong.
Advice has been consistent in and out of the government, so I will not take it that way. That yes, you want to say you want to let her go.
The problem we're facing now with the fishermen, I spoke against that section. You were on the other side and you voted against it and you advised the ministry to issue. That's what the minister said. He got advice from
Hold on, dear Senator.
No.
A law once on the books will have to be enforced and implemented. Let us not go down any grandstanding on that. My views were clearly stated. I cannot abdicate my responsibility as Attorney General to provide advice where it is requested and to assess properly what is presented before me. The advice rendered is a proper advice. Issues arise which require further investigation and consideration, and the Honourable Minister and counterpart ministers are taking up the issue. It is as sensitive for you, members of the public and the administration, but I beg you to understand that there are proper places for discussing matters. But do not grandstand with me on this one. As Attorney General, I have duties which I must perform, and you and I are not disagreed on how contentious that issue is. So let us not make quarrel on something that is too important.
I'm not quarreling. I'm pointing out very clearly that the law provides for this to be discretionary. It does not say that on an application it must be granted. And therefore, if the Attorney General was of the view that that law ought not to have been on the books.
No, you can't. You have to take it off the
Let me finish. You didn't interrupt her. If The Attorney General is of that view. The Attorney General is not obliged to advise that the jurisdiction should be transferred to a foreign state. And if the Attorney General and the Foreign Minister, who were both in the Senate when this was passed, were of the view that this amendment was wrong, both have the power now to change it, but they have done nothing. And I'm not quarreling, I'm just pointing out that you have done nothing.
Chairman.
AG.
You know, Chairman, if only we could focus our attention just to do the work at hand and sometimes don't get onto sidebar issues or make comments that is just laced with mischief, especially when there are real contentious issues to be resolved. And for my part, I have just grown weary and impatient with how we do things. And those of us to whom power is entrusted, you know, we must speak responsibly and ensure that what we say and do contribute to meaningful solutions. I wish to bring back the committee's attention to the issue of watchlists.
Before you do, if we recognize that in the past we have done something wrong, we don't just live with the wrong. We change it, we correct it. And secondly, if there was a wrong which does not oblige you to act in accordance with it, don't have the courage not to. And if that path was wrong, then we must recognize that we must not fall into the error again. And that is what I'm warning against. This is not grandstanding. This is not a side issue. If you take it as grandstanding, maybe because you're an actress. I am not an actor.
Chairman, we're not going to go back and forth. But you know,
We'll get there.
you know, Chairman, experienced counsel knows that you don't stay on the outside and make pronouncements when you do not have knowledge about facts that are presented or the information upon which advice is given.
You must listen to the radio. The minister was on radio talking about it. There was a press conference about it.
Member Knight,
representatives of the state.
Member Knight,
One of the things I find is that the representatives cannot agree amongst themselves as to what happened. Somebody is not saying
Member Knight,
what
no. The
That's
question
incorrect.
arose.
Everybody agrees, know what happened.
Chairman, question arose as to when the government became aware of allegations of mistreatment.
No.
Question arose about that.
No, I asked the question. The question arose as to whether or not the shipwrighter agreement had been breached. When and where did this thing commence, and whether the treaty obligations had been breached. That was the question I asked. Read the Hansard before you talk.
I tell you what, Chairman, let us get back to the work of the committee. So we were discussing the issue of
This is a part of the work, and this is why I'm against what we're doing.
Chairman,
because we're going down the same route. We are creating a police state.
I replied to your
Chairman,
question, Minister, and Vicar.
the issue we are discussing is whether the proposal for a watch list should be accepted by this committee, recognizing that lists have been used by the police in the past, and on what basis is a recommendation being made to move the use of a list from an administrative tool to a legislative tool. In respect of the watch list, I picked up the Constabulary Force Act as a reminder that the duty to watch is already a duty that has been legislated. And Section 13 of the Constabulary Force Act sets out the duties of the police under the Act, mandating it to watch, keep watch by day and night, among other things. And among the other things is to preserve the peace, to detect crime and apprehend suspects, etc., etc. And why I'm referencing the Act, Chairman, is to invite the JCF, and it's a matter that you would have more than a passing interest as Minister with responsibility for the JCF, about that duty of keeping watch. Because if you look on, if the research were to be done, there's a specific reason why law enforcement is mandated to keep watch. And the thinking about what can happen or should happen or can be prevented under watchful eyes. And it leaves me to wonder, as others in the public have wondered, with the absence of police officers keeping watch, where space is created for people to break the law and do all kinds of things. So by virtue of their duty to keep watch, in keeping watch, you may have a list of persons that you want to watch more closely than others. And that tool has been used. So when we come to rationalize how we are going to equip our law enforcers to carry out their job, we must understand what already exists, what is the context in which they're doing their work, what are those limitations, and what is required for effective crime prevention, among other things.
My understanding again is that withdrawal of this should not have no need to be in this legislation, because the current Police Act, as it is, gives the police powers to monitor suspects and...
It is a different concept that is being imported in here.
Right.
Totally different from the general provision in the Jamaica Constabulary Force Act, which deals with the duties of the police as against, for example, the JDF. What is being imported here is exactly what you said, and this is what gets me a bit rattled. I understand the need for tools to assist the police in carrying out their functions. I understand that.
The gang apprehension and disruption.
Yes, I understand that. And my mind went to, for example, the sexual offenders register, and to see how both could be blended. But I'm saying that when we begin now to place persons on watch lists, not because of anything specific that the person is doing, but because of a conviction that the person was subjected to. And that person now is placed on a watch list, perhaps totally rehabilitated, I don't know. At an airport, we know what happens, for example, sometimes when stop orders are placed. We know. And when you begin to place people on watch lists, for example, there are countries which will revoke travel privileges because the person is on a watch list, even though the person is not suspected at the time of being involved in any criminal activity. And so I'm trying to see how we can achieve a goal without at the same time scoring on ourselves. Because when you do that to the citizen, the state is being oppressive, and the state ought not to be. And that's why we have division of functions. There are certain persons who have the charge to see to the rights of the citizens. And that is why, but that's for another time anyway.
Okay. In that case, I think the point is made very clear now by both members as to what is permissible and should not permissible. The challenge that I am coming from a security point of view, or is there any need for an additional tool to monitor gang members and how this should be done? Now, if I pick it up from what you said there, member, and I think the way you put it has given me some thoughts that might be worth the while looking at. If the person, let's take extortion, there's legitimate enough evidence to show that a group involved in extortion exists, then we can proceed. Could we then be able to proceed to put extra tools in the hands of the police to monitor that particular grouping, which may require some kind of naming and providing the additional surveillance, or is there enough legislation to cover that already?
That's why you have an act like the Interception of Communications Act. There are provisions there that can cause the police to monitor. But, Chairman, I suggest that because of the paucity of members,
I just thought we'd finish the discussion on this one, which has proven that with a limited number, there's a certain level of intellectual jousting that is useful. I'm finding useful in my consideration.
Well, I didn't find any jousting taking place today. I didn't. Especially in the nature that you seem to be defining the exchange.
I said intellectual jousting was of someone. So, I don't think we'd need to bring it. We certainly we have to ratify what we have decided, but it seemed to me that this particular issue is covered by existing legislation in various areas. It's a matter of pulling them together. You want to make a comment before we adjourn?
Yes, sorry, Minister, I don't want to belabor the point, but I do recall in my presentation regarding the watch list and the registry, I had pointed out that the current Act already provides for, consequentially amended the Criminal Justice Administration Act 54B. And what we had proposed was that Registry of Restricted Persons be what could be the register of gang members. So once you are convicted of an offense and you are designated restricted person under Section 1, then you can actually be designated that if the minister is satisfied that the person should be regarded as constituting a threat to the public safety or public order of Jamaica. So
tell me something. The 54B that you speak of there, was that what was originally called the Deportee Act?
Right, in the Criminal Justice Administration Act.
Totally different situation.
No, but but it's the Anti-Gang Act consequently amended that to include conviction under this act for the persons to be included on the registry. And our proposal at the time was that the Minister of National Security be responsible for doing that order, as opposed to the Minister of Justice.
So that would be requiring a monitoring, and persons would have to reside in a particular locale, and if they are out, they report and so on. Is that
right? So under that subsection of the Act, the Minister by order may impose certain restrictions on the person, to include reporting to the police, registration, use and possession of firearms or other weapons, or anything that the Minister might deem to be restrictive.
If being the thing that is we are seeking to correct there is relates more to gangs involved, relates to the gang involved in transnational crime. I think the challenge to come out of this legislation is what is the best way to, we need proper legislation to deal with these enterprises. And I think what is raised there are individuals who are in transnational crime, will travel regularly, they have no illegal activity here, or they will get convicted and they continue to develop their organization. Does the current legislation cover that, yes or no? If not, you're hoping the current list now operates with the Ministry of Justice. Well, I think that will be taken up again.
And I do recall Minister Chuck at the time did say, you can go ahead and take it.
Chairman, I believe the sitting of the committee for today is drawing close, but for having sat in and listened over the many meetings, I'm beginning to think that with the help of law reform, we will have to bring forward the work of looking at the existing pieces of legislation that deal with a wide range of matters, including, if we start on the back end, how we deal with persons who have been convicted, time period for rehabilitation, where they continue to pose a threat to the society, how we're going to monitor them, how we deal with persons between charge and conviction, between suspicion and charge. Look at what is required across all of the areas of monitoring, what may be required specific to certain types of conduct. But I fear, from what I'm seeing, that either we have forgotten some of what we have legislated, or we have not fully digested and understood the existing legislative schemes for dealing with persons. And I think maybe that is part of the reason why we remain severely hampered and challenged in effectively dealing with the crime problem and matters in the administration of justice, and not just within the court side of it, but along the entire spectrum. I will flesh it out and speak to you further on it.
The Senator live stream, there's one thing that you come on, because as a layperson, I'm beginning to be concerned about the same issue, because I see too many things that are being brought to me, and I'm told that there are legislation that covers these things already. And it may have value, Mr. Bailey, at these, well, what you said, Mr. Bailey, bring these together, what we need to look at, or what the implications are, if there need to be further amendments there, or just to get them together so that they, well, who is supposed to be putting them all together? DPP and police?
Chairman, I suggest this. If it has not happened before, I suggest that the Minister of Justice, the Minister of National Security, and the Attorney General and the support staff meet together and go through this, because what is coming across is that the right hand is not sure what the left hand is doing. And it's not, I don't feel a cohesive thinking on the issue. So if it hasn't happened, and this is not a criticism, if it hasn't happened, I suggest that you do that. There was a time when the Minister of National Security was the Minister of Justice. And so, you know, different considerations yes, arose. You see, and then the Attorney General would come in sometimes. So I'm just suggesting that you do something like that. And
certainly of value, and some of that work has been done, Senator, but it may be worth the while looking again at the cross-cutting legislature we have in mind. I said the committee is somewhat limited today, and I just, AG.
Note on which Member Knight and myself can agree. I would only add that the work more needs to be done below the level before it escalates up to the ministerial level. But
in a note for all of us, in the
it's a good note on which we agree.
So the one technical leave can leave and pull it together, and we have further discussion. And as I said, intellectual Joseph might have had something to do with coming to a good agreement in the end. No, I think we'd come to, as we said, the committee is restricted today. The next item shows where we had done some work with legal reform, just to indicate that that is proceeding. I think we are pretty, they are with you now, AG. I don't normally say that. We send them to you to just look at them and I bring them to Parliament. And they'll add one thing to it. But we can adjourn now. We need to set a date that we think we can get as many as possible and instruct the Parliament to begin to pull the notes together. We only have a short thing to go, but we need to ratify with it today and at the same time conclude this. I really need to set a good day that we can get this done. We have been a little bit slow in getting to this point, and this piece of legislation, we need to get it out and get it concluded. There are some dates here free. Which Wednesday? What's the next Wednesday that's open?
No, sir.
No Wednesday?
Not until the end of the month.
Well, AG, you're traveling from when? In July? First week of July?
This Tuesday morning is free.
There's a Tuesday morning which is off, no CDF. What happened there?
No CDF at 9, but the other meeting would be at 10.
And that's the 9th of July?
Chairman, I mean, while I may be required for quorum purpose, should it be considered necessary to have the meeting, I believe the learned Solicitor General will ably represent the Office of the Attorney General.
Cindy, we'd miss you, but as I said, the intellectual jousting can be good when you're I better. The morning of the 9th, most MPs should be around, and I'd hope, Senator, you're saying a Tuesday is bad for you as well. 10 to 12? No, Tuesday's Parliament. There's a morning that's free for us here. Tuesday the 9th. Which one? The 9th?
Yes, sir.
The 2nd is not available, right?
Yes, it is. So far.
There are a couple of Tuesday mornings available. Could you make one available, Senator? All right. Tuesday 2nd is when? Next week. I really like to bring it to conclusion. And the prize givings, how do they go? They're not usually on Tuesday morning. I think they keep Tuesdays for Parliament. We're getting prize giving, we're getting flu, we're getting, and the campaign. Senator, are you guiding the young Turks in their activities? Do they keep Tuesdays free from the campaign field trips? They stay close to home on a Tuesday. I thought as an elder you'd be giving some guidance to have a healthy campaign while doing the duties. I'm inclined, I know Tuesday is difficult for me, I must tell you, but I'm thinking that I'd start with next Tuesday. I'd love to bring this part of the discussion to a conclusion so we can begin to look at. We have 2 Tuesdays. I could start next Tuesday, and we should be able to finish it in one day. This part of it, the review. It's just 2 pages left. Tuesday the 2nd, I will arrange for my other activities to be taken elsewhere. As whichever suits you best, we'll let's.
This one would allow for the report to be finished.
Mm-hmm.
So if I don't know if we could skip this, then
Skip that? Let's go for Tuesday the 9th, and we'll have a full report to where we are now. But would you be here on the Tuesday 2nd, madam? Let's do it on Tuesday then. Let's finish it up.
I was thinking if I could get the report together, then I could have it ready for that time.
SG will be not traveling. Well, the clerk is suggesting that she could.
Next week, Tuesday, you know, Chairman.
Yeah.
Right. And we have a number of housekeeping matters to do. We have the minutes to go through. We need. We have to look at the recommendations.
We do one on Tuesday the 9th.
So I suspect it may not be the ultimate meeting.
Yeah. No, we have other things. I was just trying to go through this part of the document. I'm going through this.
Okay.
All right, Tuesday the 9th, 10 o'clock, and we go through this.
Tuesday the 2nd, which is next week,
Tuesday
but the week after.
Yeah.
I won't be here, but
some time to pull some more data together in terms of what the minutes and the report. All right, please, but make sure you get this done. All right. Don't really need to tidy up this piece of legislation. I've been going to review, and I know the facilities in Parliament itself restricts our timing, but we need to get this done. I want to thank all the members who are here today, and restricted, we did some good work. Let me thank you. And Tuesday night we meet. We hope we can finish this part, which is to go through these items here. All right. Thank you.
We know times are hard, but can selling your vote really make a difference in your life? How many of them even remember you and your community? What you need is opportunity for yourself and for your children. Don't sell your vote. It is illegal. Respect your vote. Vote for opportunity. A message from USAID Comet 2, NIA, and partners.
Hello, I'm Dr. Carlton Bird, Speaker Director for Breath of Life Television Ministries, and I want to encourage you to watch Breath of Life right here on PBCJ.